Good afternoon. My name is Joseph Malchioni, for those of you who don't know me, and today we're here to discuss everyone's favorite topic in workers' compensation law, fraud and concealment in the state of New York. This presentation is for instructional purposes only and is not legal advice. Attending this presentation does not create an attorney-client relationship between the attendee and LOIS Law Firm or me, the presenter. So, fraud. Fraud is perhaps one of the most exciting topics in our practice. Why is that? It's because fraud focuses on probably the most pop culture aspect of what we do in New York State workers' compensation defense, right? It's the CSI, it's the law and order aspect of what we do. You know, it's the investigative, the mystery part of our practice. These are the stories you're going to talk about at the water cooler the next day with your friends over cocktails. And here's the good news. Virtually all of our cases contain some level of exaggeration. And raising and litigating fraud is one of the primary ways in which we as a law firm promote one of our core values to aggressively advocate for our clients. Now, in today's presentation, we're going to discuss what exactly is workers' compensation fraud, how workers' compensation law section 114A defines fraud, what are the potential penalties for finding a fraud. We're going to talk about the tradesman and progeny cases, how prevalent workers' compensation fraud is anyway, and what we do about it every single day in defending our clients. So, to begin with, what is workers' compensation fraud? Well, very simply speaking, it's lying about a material fact in order to get benefits. According to statute 114A, if for the purpose of obtaining compensation pursuant to the statute, or for the purpose of influencing any determination regarding any such payment, a claimant knowingly makes a false statement or representation as to a material fact, such persons shall be disqualified from receiving any compensation directly attributable to such false statement. In addition, the claimant shall be subject to a disqualification or an additional penalty up to or foregoing the amount directly attributable to the false statement. What does all that mean? Well, it means that the fraud statute in the state of New York is powerful. And why is it powerful? Because the potential penalties for a finding that a claimant has violated the statute is forfeiture of awards, or in certain extreme situations, even restitution, where the claimant would have to pay the carrier back for monies paid. Now, interesting fact, there was no fraud statute in the state of New York until 1998. Think about that. Does that mean that 25 years ago, no one was committing fraud in the state? Of course not. It just means that there was no way to penalize someone for committing fraud. The good news for us today is that the statute exists, and we rely upon it every single day to advocate for our clients. So, what do we need to prove in order to show that a claimant has potentially violated section 114A? Well, we must prove that with substantial evidence supported finding that the claimant knowingly made a false statement in order to obtain workers' compensation benefits. And the standard substantial evidence, what does that mean? It means more than just nothing, more than just a mere allegation that the claimant made a false misrepresentation, and that the misrepresentation was made willfully and knowingly, and for the purposes of obtaining either medical or indemnity benefits. Basically, put your law school hats on, right? We have to prove mens rea. Anyone in the room know what mens rea means? I don't see the microphone, so I'll just tell you. So mens rea is the thought, right? There's thoughtful intent. So a claimant, we must prove that the claimant had knowing knowledge or the intent to make a false misrepresentation in order to constitute a claim to get benefits. Now, the only benefit that is affected by a finding of fraud is indemnity benefits, meaning that even in the most egregious cases of a violation of 114A, the claimant could be precluded from getting additional or prior indemnity benefits, but a claimant will always be entitled to causally related medical treatment. Now, why do we think that the legislature provided this safeguard? Well, I think it's because it's for public policy reasons, right? So even in the case of a mistaken finding that a claimant has violated section 114A, at the very least, that claimant will still be entitled to causally related medical treatment for the life of the claimant or until the claim closes via settlement. But that doesn't minimize in any way how powerful section 114A is and how we use it in our daily practice. So let's talk a little bit about the types of evidence we use to support a fraud allegation. So perhaps the most ubiquitous and common form is surveillance, covert surveillance. Now this is your typical investigator that's following a claimant in a car or hiding behind a bush, capturing a claimant as they're doing seemingly mundane things like walking the dog or going shopping or taking their kids to and from school. We also can rely upon non-covert surveillance, which in our everyday world today is plentiful, right? This is the claimant's self-surveillance. He or she putting their life out on social media and providing us with all of the wonderful things that they're doing while they're supposedly out on disability, receiving temporary total disability benefits. And we are finding more and more over time that this is a very powerful form of evidence. So what are the most common forms of fraud that we see? Well, exaggeration. It's amplifying the severity of a real injury to extend benefits. This is, I'm going to the doctors once every 3 months, and I'm claiming that I can't even bend down. I can't walk 1 foot without being in excruciating pain. I'm exaggerating the nature and the extent of my disability in order to maintain an entitlement to lost time benefits. Faking injuries. This is claiming a workplace injury that never even happened. How many of your cases are unwitnessed accidents or concealment, right? Working off the books or getting money from another source and not reporting that while being out and receiving lost time benefits. But there's also some more harder to detect forms of fraud, right? Violation of undue influence regulations by third-party actors like litigation funding companies. Crooked doctors overtreating for vague injuries. We see that all the time. Crooked billing practices by corrupted medical providers. The use of runners to generate claims. We're going to talk a little bit more about that later on. The use of stolen identity to create alleged employees. And the coordination between all of these bad actors, law firms, runners, doctors, and litigation funding companies to generate false claims. So why is Section 114A such a powerful tool for us to use? Well, there is an ever-present affirmative duty on a claimant to be truthful at all times. They have to tell the truth. That's just part of a claim. Everyone has to tell the truth. That duty is absolute. So, and that duty also extends to people acting on behalf of the claimant. We see that in a situation where a claimant may not speak English and they have someone testifying on their behalf. Well, that duty to be truthful extends not only to the claimant, but to anyone that's acting on behalf of the claimant. So a claimant can't feign a misunderstanding or there was a loss of translation simply because the translator lied on his or her behalf. Also, claimants must disclose all personal activity, whether work-related or not, or whether they get paid for it or not. This is, I'm out on temporary total disability benefits, but I'm also volunteering at my church, or I'm acting as my son or daughter's referee for their sporting events, or I'm volunteering in my community. Now, they may not be getting paid for these things, but they're certainly behaving in a way that requires them to physically behave, physically act. If they can do those things and not get paid, they can certainly go back to work and their entitlement to lost time benefits. The fraud doesn't have to be just for money. It could just be for the benefit, right? So a claimant could be working at a family business while they're out, right? I'm out on disability anyway, I'm getting paid, might as well help out and work the register at my family's business. Well, there's still a benefit being derived by that. There are still physical actions that go with behaving in that way. If you can do that, you can go back to work. And if you lie about it, that's certainly fraud. Already paid benefits must be rescinded. And the good thing about these things are board determinations that a claimant lied, concealed, or was untruthful, violations of 114A are very, very strong. And they most likely will not be overturned on appeal. Do we know why that is? Again, I don't see the microphone, so I'll just provide you with the answer. It's because the board, the trier of fact, the law judge, is in the best position to make determinations with respect to credibility. So therefore, unless a decision regarding a violation of 114A is capricious, arbitrary, or completely based on a misinterpretation of the facts, the full board or any appeals tribunal is more likely than not going to defer to the credibility of the lower court and uphold the 114A finding. So getting a finding of 114A is a very powerful thing. So now it's the fun stuff. Let's talk about different examples of fraud. Well, first of all, working while receiving temporary total disability benefits is certainly fraud, right? And even passive income can count, right? Working on, like I said before, working at a family business, not getting paid, or getting paid through another business that doesn't require any physical activity, you're still earning income and you're not reporting that, and you're receiving or maintaining an entitlement to lost time benefits, if you lie about that or don't disclose that, that's a violation of 114A. Unpaid activity on a new business not yet opened. In this situation, the claimant alleged that, well, sure, I'm receiving temporary total disability benefits. What better time than to work on setting up my own business? I think in this situation, he was setting up a bar, right? Well, if you can take steps to set up a bar, whether it be building the bar or setting it up from a financial perspective, and you can take those steps, you certainly can do some sort of work activity to end your entitlement to lost time benefits, right? And this person most likely completely innocently believed, well, I'm doing everything I can to get off benefits. But hey, wait a minute. That doesn't alleviate your obligation to be truthful about what you're doing in your current physical capabilities, because the carrier's still on the hook to pay you lost time benefits. Failing to disclose a prior injury to the same body part, and it's whether or not that body part is, or that injury was work-related or not. This is very powerful too, right? A claimant cannot escape a fraud finding by simply saying, yeah, you know, I had a prior left shoulder injury, but it wasn't work-related, so I didn't think it mattered. Nope, doesn't matter. If you had a prior injury and you reported that prior injury, and you didn't report that prior injury on your C3 form or to your doctors, that's a violation of 114A. Making up an accident, staging an accident. This is when you see on the news. This is when New York Workers' Compensation gets on the Channel 7 news, right? You see the claimant, they're at the supermarket, they think no one's looking. They walk down the aisle, they look left and right, they don't see or notice that there's a video camera capturing everything they do. They grab, like, I don't know, like a jar of pickles, drop the pickles on the floor, look around, gingerly lay down and start writhing, and everybody comes and they say, oh my God, he was injured, it was work-related injury. Little do they know it was completely caught on camera. So that's very common. The claimant reporting to his employer and two physicians that he sustained an injury when he slipped and fell on ice on the premises of the employer, when in fact he was injured during an altercation with a coworker, which occurred at the conclusion of his shift. The claimant only admitted the truth upon his coworker's refusal to participate in the lie. This is lying about a fake accident. That's double fraud. Misrepresenting activities of daily living. I think this is also an extremely common area where people lie, right? This is, I'm telling my doctors I can't tie my shoes. My pain is a 10 out of 10. I can't get out of bed most days. But then when we or our clients secure surveillance of them, they're doing seemingly boring, mundane things, right? We're capturing them going to the store, going food shopping, taking their kids to and from school, right? Doing light yard work, shoveling, raking. Now, claimant thinks this is no big deal. I'm off, I gotta do these things anyway. But this is when seemingly mundane surveillance becomes extremely powerful, right? Because when the claimant is telling his or her doctor that they can't even stand up, they can't walk one city block, they can't bend down to tie their shoes, yet we have a video of them shoveling snow, lifting up 80-pound bags of dog food at the supermarket or at Home Depot. If they can do those things, they're certainly lying about the extent of their injuries. And suddenly that seemingly mundane covert surveillance of the claimant doing his routine daily activities becomes extremely powerful in the context of litigating 114A. Criminal activity resulting in income. Believe it or not, perpetrating criminal acts is fraud, right? Selling drugs, prescription or narcotic, is a job. Diverting prescription drugs, selling drugs earns income. It's a job. And if you're doing it, you are committing fraud in the state of New York. We see this sometimes with claimants that are getting $4,000 monthly prescriptions for opioids. Yet when the doctors are testing them periodically to make sure that the appropriate level of the opioids in their system, it doesn't change. Where is all that going? Well, maybe they're selling it. So a criminal act and selling the drugs and not reporting that is fraud upon fraud upon fraud. Magical improvement when outside the doctor's office. This is also the cartoon version of fraud, right? Claimant is injured. I remember when we used to go to court and claimants would come to court and they try to substantiate their claim. They would come in and they would walk slowly into the courtroom. And those of you who've practiced for a little while would remember this. They're barely able to sit down. Their attorney has to help them. They can't stand up. They got to be helped out of the building all the way to their car. But then there's a covert surveillance person, investigator standing on the corner and catches them ripping off their neck brace, throwing their crutch, clicking their heels, and acting seemingly perfectly fine. So, how prevalent do we think fraud actually is? And although no one knows for sure, there is exaggeration in very, very many claims that we deal with. And what we need to think about is whether or not that exaggeration can lead to either a tactical or strategic advantage for our clients, right? The New York State Inspector General Workers' Compensation Fraud Inspector General's 2023 annual report offers some insight, right? The 2023 report noted that there were 11 arrests and $768,000 in fraud cases detected, resulting in $1.3 million in fines and restitution. But only 4 of these matters involved claimant fraud. Think about that. The entire report for 2013 uncovered $1.3 million in fines and $768,000 modified in fraud. Think about that. That's basically one workers' compensation case in most cases, right? And while these dollar amounts seem significant to some, they reflect only detected and prosecuted fraud, which means and indicates that there's a great deal of unrepresented fraud. And the true scale of the fraud is difficult to discern. 4 cases. This is obviously way outside the proportion to the fraud that we see on a daily basis. Now, every time I conduct this presentation, I like to note that when I started practicing workers' compensation defense in New York about 10 years ago, almost 10 years ago, I didn't see fraud litigated as much. But over the course of the last 10 years, the number of cases of fraud that's litigated and the number of fraud wins that we ourselves achieve has expanded exponentially. And I think that's in large part due to the fact that we as a firm are so aggressively litigating fraud, holding claimants to the standard, and bringing these issues out to the court. They have no choice. They have no choice. The court has no choice to find fraud in some of these examples. Now, as you can see from what we post on the wins on our website every week, we are getting about 1 fraud finding a week, and we estimate that 10% of our cases involve fraud of some type. So when you think about that in context, the Fraud Inspector General data clearly does not represent the true fraud that is occurring throughout our cases on a daily basis. Which brings us to probably the most significant happening related to workers' compensation fraud litigation in the last 25 years. And that's the Roosevelt Road and Tradesman RICO lawsuit. These lawsuits were filed in 2024, and they allege a massive fraud ring involving over 700 potential fraudulent claims with median settlements of around $2 million. And the plaintiffs in these claims, representing insurers, claim that there's a mass amount of staged or exaggerating accidents, often targeting immigrant workers, that drove to increase the claim adjustment expenses from $14 million in 2018 to approximately $142 million in 2022. Even contributing to one carrier's exit from the New York market. That is an incredible increase in a very short amount of time that wasn't arbitrary. Some of the allegations in the tradesman case include medical professionals, law firms, and claimants working together to commit acts of fraud in order to obtain payments or benefits by defrauding the New York State workers' compensation system. Allegations include law firms utilizing runners to recruit and fabricate injury claims, people that actually go out and solicit people to file fraudulent claims. Some of these victims are even unaware that they're plaintiffs in a lawsuit. Medical providers are billing for treatment that's never been performed, whether it be diagnostic tests or even in the most extreme examples. And this has been proven. Doctors claiming that they are performing surgeries or actually performing those surgeries, cutting people open, not doing anything, sewing them back up, and then charging the insurance companies for the services. Think about that. And the use of mail and electronic transmission of medical bills brings this within the purview of wire fraud. Now, if these allegations, what do these allegations mean? The allegations in trades mean that hundreds and more likely thousands of faked injury claims were filed. And because they involved construction accidents, medical care was provided by workers' compensation carriers. Now also think about 90% of the workers' compensation claims that actually take place in the state of New York don't ever reach a litigation phase or are controverted. So think about that. We usually, the cases that we handle here in this firm represent a very, very small percentage of the overall number of workers' compensation claims that even reach the light of litigation at any point, whether they be controverted or whether there's some treatment dispute that requires litigation. That means there could be up to 90% of cases where claimants just file a claim, whether fake or real, get paid for a period of time off, and then when they're done and they want to go back to work, they simply go back to work. So when you look at it from that perspective, the scope of the fraud that could be happening in the state of New York every day is way greater than is even imagined or contemplated by the statistics that we've reported today. And the treatment was directed to a network of participant medical professors named as defendants, many of whom you all already know. We deal with many of these allegedly bad actors on a daily basis. I'm not going to go through the entire list here, but some of the names that may jump out at you are Dr. Kaplan, Dr. Grimm, Dr. Marola, Kolb, Surgicare. Now, for those of you in the room, I don't know if you have it, but certainly those that are watching from somewhere else, we have created a handout that's been provided. This handout includes a matrix of the defendants and it includes which claims are involved so that you can see just how some of these defendants and these actors are all connected in these cases. And I encourage you to take a look because there's some very interesting and surprising connections there. So what's the status of all these cases, right? Well, they're still in the early discovery phase, right? RICO claims are complex. They could take up to many years to litigate. So they're still in the early process of litigation. But how does this impact our daily practice, right? Nearly all of the medical defendants in the tradesman case are commonplace medical providers in workers' compensation cases that we defend every single day, right? We're cross-examining them on their participation in the alleged schemes all the time. Many are refusing to testify, and many are becoming belligerent when we raise the issue during cross-examination, right? Our good friends like Adam Foreman and Joanna Grusso, anyone that's raised these issues in a deposition in the past few months know that you're going to get extreme belligerent blowback from these people. But I want you to think about something. Raising the issue that goes to the core of the credibility of not only the doctors you're deposing, the medical reports that these claimants are using to continue their claims and their entitlement to lost time benefits, but also the other the attorneys that are on those depositions. They are named defendants in these cases, some of them. Some of the lawyers that are named are Subin and Subin, our very good friends, Fogelgaran and Foreman, and of course, Goriev. And that list is expanding every single day. Right, well now I think Foreman has conspicuously stepped out of the game and has handed their cases to Goriev, so I think that's interesting, don't you?
No, I'm saying Adam is with Goriev.
Oh, okay. All right. So the discovery that's coming out of these cases is very revealing. What it's showing is that law firms may have used people such as ex-police officers and others to threaten illegal immigrants into filing claims or just simply stealing names. They're using social clubs, primarily those of illegal immigrants, to recruit people to file false claims. And many of these accidents are completely and utterly made up. Now, lawyers in civil actions are trying to withdraw as counsel or have already withdrawn in hundreds of pending cases, such as Subin and Associates. We'll talk about that case later on today. The lawyers in the workers' compensation cases are withdrawing as counsel in individual cases. We are seeing that already, and new cases are being filed every single day. Now, what has happened since 2014 in the filing of the tradesman case, right? Well, shock. Once this information has been brought to light and it's public, we're seeing other cases being filed. The Roosevelt Road and Subin case was filed on July 19th, 2024. And in that case, the plaintiffs alleged that lawsuits targeting Subin Associates for allegedly collaborating with runners to orchestrate fake accidents. It cites to Subin's May 2024 withdrawal from 200 to 300 cases due to concerns with referral sources as evidence of complicity. Think about that. Virtually overnight, Subin and Associates withdrew from 300 cases saying, well, there's some concerns due to referral sources. If that isn't an indication that they're afraid of something or that there may be evidence of wrongdoing, I don't know what is. In the case of Roosevelt Road versus Wingate, which was filed on September 6, 2024, 38 named defendants, including Wingate, Shapiro, Bangle, Cohen, and Falconetti, whom we know very well, and other actors that we know. The allegations are they accuse the defendants of coordinated scheme involving unnecessary surgeries, falsified medical reports, and inflated personal injury lawsuits, specifically highlighting particular providers, such as someone we see every day in our practice, Dr. Kaplan. And it's been reported that Dr. Kaplan was involved in 75% of the cases that were involved. 75%. Anyone here that's deposed Dr. Kaplan or has read any of his reports, that should come as no shock to you. The damages claims are consistent with the prior filings, multi-million-dollar losses, and systemic market harm. More recently are the Ionian case and the Uber case in particular, filed in January of 2025. Now, the Uber case has facts very similar to that of the initial tradesman case. In that case, the plaintiffs are alleging that Uber passengers, lawyers, and medical professionals, many of which are also named in the tradesman case and its progeny, were involved in a giant scheme, fraud scheme, alleging fake injuries or significantly exaggerating the injuries in order to obtain false medical treatment or large settlements. Now, what's going on in all these cases? Again, as I stated before, all these cases are still in the early stages of litigation, but we as a firm are consistently monitoring their status so we can determine how they each would be impacting our daily practice. Now, for all of these claims, whether they include a RICO defendant or not, how does all of this impact our day-to-day defense of our clients? Well, as you know, our focus at LOIS is to take concrete tactical actions to create jeopardy and movement in our claims. We take a proactive approach to claim handling. We create an action plan, we report that action plan to our client, and once aligned, we take that action. What we don't do is we don't react, we don't wait. We do not wait or react to our adversary's action or inaction, or the court's action or inaction. We are affirmatively looking in our cases to find action areas. And again, fraud is a major source of that information. So how does this all translate in the context of a fraud case? Well, in a fraud case, the tactical action is simply raising the issue of fraud. And anyone that's litigated a fraud case, whether it be you started last week or you've been doing this for 10 years, knows that by simply saying the phrase, Your Honor, I am raising 114A at the start of a hearing, you are immediately going to get the attention of the adversary, of the claimant, and certainly the claimant's attorney, right? Because they immediately think, well, wait a minute, they know something that we don't know. So right then and there, after those words leave your mouth, we already have some sort of a leverage or tactical advantage. Whether or not litigating fraud in that particular situation ends in a strategic victory, we've already created a tactical advantage for our clients. And who knows, we may end up with strategic victory. Because when you open up Pandora's box, you never know what will be revealed. So, after litigating cases and being very successful for many years, our firm recommends a very concrete set of best practices that should be considered when litigating fraud cases. So for one, for covert investigations, we always recommend multi-day surveillance. And when we do that, we always recommend a different investigator is used for each day. So if we recommend, let's say 4 days of surveillance, we tell our clients, okay, fine, you want to do 4 days of surveillance? Please assign a different investigator for each day that the claimant is surveilled. And in a few minutes, we'll talk about why we recommend that. We also recommend never generating surveillance reports that correspond to the surveillance that's captured. Again, we will talk about why we don't do that. But if a report is a must, then we recommend that the investigator generate a separate report for each day of surveillance. 4 days of surveillance, 4 different investigators, 4 different reports if a report is absolutely necessary. We also make recommendations for the best time to conduct surveillance, right? Now, does anyone in this room think it's a good idea to recommend surveillance in the dead of winter on a Friday at 6 o'clock outside of a multi-dwelling apartment complex in the city of New York, when everybody is looking like, what's his name, Cartman, with his, hood on, and everyone has gloves and their faces are covered? No. When's the best time to recommend surveillance? In the spring, on a Saturday, when it's beautiful, or before or after medical appointments, when claimants suddenly have an attack of the truth or suddenly have a magical improvement when they leave the doctor's office. So why do we do these best practices? Let's talk about it. Well, our firm has over 10 years of experience in litigating these issues, and we have got this down to a science, right? We've even made the appellate case law where we don't have to produce the surveillance report. It's considered attorney-client privileged information. So we know what we're doing. Let's take a look at a scenario where a client doesn't follow our best practices, right? This is the same investigator is used for multiple days of surveillance and a report is generated. What happens? How does that look? Well, what is the claimant's most common defense to our good surveillance? Good days, bad days, right, Judge? So yes, you caught my claimant for 15 minutes, exercising in the park, but geez, you should have seen him the next day. He was laid out for a week. Please don't penalize him for trying to get out and exercise so he can get back to work. You didn't see him the rest of the days. In fact, you got 2 weeks of surveillance and all you got was 15 minutes of the claimant acting inconsistently with what they're telling their doctors. Now think about that for a second. It's a red herring, right? If the claimant can do that rather, then it shouldn't matter whether they're misrepresenting, making a false misrepresentation regarding 15 minutes, 20 minutes, 2 days worth of their behavior, or 2 weeks, right? But the judges in our cases are so willing to avoid a fraud finding that they're going to look for any reason to rule against us. So we don't even want to leave ourselves open to that, right? In this situation, the length of surveillance works against us. Also, if we submit reports, we are opening ourselves up to the cross-examination by our adversaries of those reports, right? So they're going to look through with a fine-tooth comb every aspect of those reports. They're going to find every period that's in the wrong place, every misspelling, and that's what they're going to focus on. Judge, the investigator made a mistake here, spelled the claimant's name wrong, got the dates wrong on page 4 and 5. The period's in the wrong place. Judge, clearly the entire report is not credible, and therefore all of the evidence is not credible. All got to go out. It's all got to be precluded, right? And these judges are more than willing to preclude all of our evidence. So we don't want to give anyone the opportunity to impugn this credibility. So now let's look at that same scenario with our best practices. No reports are generated whatsoever. Multi-day surveillance and a different investigator on each of the days that the claimant is surveilled, right? Well, first off, if there's no report, there's nothing for our adversaries to cross-examine. There's no document for them to impugn, no argument to be made that because a period is in the wrong place on page 15, that all of the evidence should be precluded. That nullifies that argument completely. It also eliminates the good day, bad day defense completely. Why? We have 4 days of surveillance, a different investigator each day. Okay, 2 of those days we catch the claimant shopping, catch the claimant working out at a gym. 2 of the days they're just sitting outside for 10 hours doing nothing. I believe it's this firm this year, and the name of the case escapes me, successful in getting the court to find that we only have to submit the surveillance that we plan to rely upon. In other words, if we have 15 days, but we only want to rely upon 2, we don't have to submit all 15 days. We only have to submit the evidence we rely upon. So in that situation, we only submit the 2 days that have the compelling evidence that the claimant was misrepresenting his or her disability. And then how does it look? Well, the investigator gets up. There's no report to be cross-examined on. And we ask the claimant, well, how many days were you asked to surveil this claimant? 1 day, okay? What did you see on that day? Well, I saw the claimant working out at the gym. I saw the claimant going out to the park. I saw the claimant food shopping. Okay, thank you, Mr. Investigator. Next, bring up the next investigator. Ma'am, sir, how many days were you asked to surveil the claimant? 1 day. And what did you capture them doing? All of these things that are inconsistent with what he or she is telling their doctors. Now suddenly it looks like every single time the carrier puts a surveillance on this claimant, they're catching lightning in a bottle, and they're catching this claimant left and right. And it makes our fraud arguments way more compelling, and it makes it very, very difficult for our adversaries to impugn the credibility of our evidence. If you get nothing else from this presentation today, it's how important these best practices are in just dealing with the fraud evidence that our clients spend so much money obtaining. Okay, fraud is both strategic and tactical. Fraud is strategic because if you win, if you prevail, you can foreclose the claimant's entitlement to future indemnity. You can get reimbursement for previously paid indemnity. And a fraud finding can result in criminal prosecution, very rarely. But here's what we do know. Once the money stops flowing, the medical treatment usually ends. And what else ends is our client's exposure. Fraud is tactical because it's one of the few ways, one of the few strategic actions we can take where we don't have to reveal the supporting evidence until after the claimant testifies. That's a huge benefit, right? Because, like I said before, once you immediately raise the issue of 114A, you immediately create that leverage. And whether or not you litigate that 114A to a strategic win or even a loss, if it gets the claimant to settle or go back to work or end their entitlement to lost time benefits in any other way, we've already won, right? So we can bluff with weak fraud cases to see what shakes loose. And here's the best part. It's not like preemptory challenges in civil court. You can raise fraud over and over and over again. There's not a finite number of times you can raise fraud. So therefore, there's no reason to be bashful. There's no reason to wait. Here's some additional best practices. Do raise fraud at the earliest opportunity after you are certain there is substantial evidence to sustain a defense, right? Because remember, we only have to raise fraud as soon as there's anything more than a mere allegation. And also consider what I was talking about before. A lot of times we've all seen this surveillance evidence, right, of a claimant just walking the dog, go to the park. It doesn't seem like anything's going on, right? But in the context of what that claimant is telling his or her doctor, that seemingly mundane fraud becomes very, very powerful. There's no reason to wait until you get the best fraud evidence to entrap them, get them dead to rights. Because, again, sometimes just the raising of the fraud will create a tactical advantage. And even if it doesn't, arguing that a claimant can go food shopping and be on his feet or her feet all day long when they're telling their doctors they can't even tie their shoes is very compelling, and it may result in a strategic win. So don't wait to raise fraud. Also, like I said, you don't want to wait until you have the perfect case to entrap, because the case law governs that there are certain times when a claimant has testified, the record has been closed, or after summations have been filed, where we may be precluded from actually raising the issue. So there really is no reason to delay raising fraud. The takeaway is raise fraud early and raise it often. Now, do carefully plan your cross-examination in order to entrap. I think I've said this every time I've done this. Fraud trials are my favorite trials to conduct. Not only because we have all the evidence, we know what we have and no one else in the room knows. So you got everyone on the edge of their seat in a system that is predicated on lies. Again, I'm a little biased, but we are in the driver's seat. We are the ones running the show. Now, although leading questions are not allowed, we do it anyway. We're going to ask leading questions until the judge stops us. I've never been stopped. I've done dozens and dozens of fraud trials. I've asked all kinds of questions. In my experience, I can't speak for everyone, no one's ever stopped me from asking questions, because the judge is also listening to see what shakes loose. And the claimant doesn't know, and the claimant's attorney doesn't know what's on those videos, right? So they can have attack of the truth. So you want to carefully plan your cross-examination, and you want to start by asking broad questions, right? So I usually start like this. I review the record and see what the claimants were telling their doctors during the months of the surveillance we got. So in February of 2024, you were examined by Dr. Kaplan, correct? Yes. And on that date, you told Dr. Kaplan that you had pain 10 out of 10, so much pain you couldn't even tie your shoes, right? Correct. And you weren't working at all during that time, right? Correct. And then I start with big picture questions such as, so did you go on vacation? Did you go anywhere during that month? No. Did you go shopping? Did you go out to eat? No. Did you engage in any social events or sporting events? No. Now I know that he was working on the car with his kid, right? That's what we have. That's on the video. The guy was working under the hood of the car. Do you work on the car, on your cars? Do you do your own car work? Now the claimant's starting to sweat. They don't know what we have. Well, did you work on your car? Well, maybe. I did a little bit. I had help. My son was helping me. I didn't do much. Oh, did you ever lift a car hood? I know Shrieks knows this case because he litigated this case. Did you ever lift a car hood? Well, I don't know. And here's the good thing, right? If the claimant lies on the record and testifies that he or she didn't do what we're alleging that they did, the video will show that they lied and we got them. If they tell the truth and say, well, yeah, it was just this one time, did you report that to the carrier? Did you report that to your attorney? Did you report that to the court? No. If they lie, if they tell the truth, then we've got them. It's like a catch-22 for them either way. So it's very, very powerful. You want to carefully plan your cross-examination and fraud cases to entrap, and they're so much fun to do. You don't want to allow weasel words or vague phrases like from time to time and waxes and wanes, right? You want to really hammer down on those limitations. So you said that you can't do any activity most of the time. Is that correct? Well, how long could you stand up? How many city blocks could you walk? How many pounds could you lift? Really try to hammer that down, because then you can, the fifth presumption of workers' compensation law is we can argue that what they tell their doctors, which is part of the record, can be used for the truth of the matter asserted. So you're telling me that you couldn't lift 10 pounds? Well, 5 pounds or 20 pounds, but you told your doctor you couldn't even stand up, right? So very, very powerful. Don't signal where you're going. There's no rules here, right? I think a lot of times we feel like our world is filled with order, but there's no order here. We're running the show in these fraud cases. We don't have to signal where we're going. We can ask questions in non-chronological order. We can hit them with zingers, catch them off guard, because it's hard to perpetrate a lie, even when you're prepped, when you don't know what the questions are going to be or what the questions are coming. So beyond the information that we have on the surveillance showing that they've committed a fraud, we also can paint a picture that they're wholly incredible, because you seem incredible when you're lying. All of us have done it from time to time.
I think that's one of the best things to do in a fraud trial is to just throw random questions in there that are not in order, because they're expecting and waiting, or not expecting, but they're trying to see where you're going to go. I just sometimes just pull something completely out of my, what, and just ask them something strange and then come back, because I just get them off topic. It's something I do a lot, so just
Thanks, Matt. Okay. Do confront them with as much documentation as we can locate. The substantial evidence can be created at trial. Back it up and back out of the court statements where you can, right? So this is, Judge, please refer you to doc ID 456392. Medical narrative report of Dr. Smith dated 4/19/25. So as the claimant is testifying, as they're lying, the judge is literally looking at that document and what the claimant was telling their doctors during that time, when we have the video of them doing pull-ups for 2 hours in the park, okay? And suddenly that evidence becomes even more powerful. And don't allow claimants to squirm out of a fraud finding by merely finding that the witness is incredible, but then still finding PFMECR disability. This just means don't allow a law judge to say, yes, the claimant lied. We had a case, I forget the name and I won't say it here, but where we allege that the claimant had 30 prior motor vehicle accidents and failed to disclose every single one of them, with many overlapping injuries. We submitted evidence by way of an ISO report that listed 30 claims. The claimant on direct examination testified that she just didn't remember, right? At the trial court, the law judge said, I just can't imagine how you could. I remember when I was 15 and I had a car accident, a fender bender. You don't remember 30 prior accidents? Clearly this is fraud. Believe it or not, it was overturned on appeal, and it was determined there was no violation of 114A. But here's the powerful thing. We can appeal, right? So I always tell attorneys when I'm providing mentorship or information about conducting these types of trials, I want to win every case as well. I want to go in and present the best case in defense of our clients. However, I'm always thinking about the appeal. If I win at the trial level, great. But when I'm asking my questions or I'm making an oral summation argument, I'm making it clear, I'm making it concise, I'm using the evidence, I'm citing to the document in the record, so that in the event that I have to appeal, and many times we do, I have created a clear and beautiful record for hopefully saner minds to address the evidence that's before them, okay? So with respect to the RICO cases, I know we've all seen this before, but it cannot be understated now more than ever. When you're cross-examining a medical professional, these are the types of questions you should be asking. Isn't it true that you've been named in a lawsuit claiming that your actions have led to millions of dollars in fraudulent billing for medical treatment which never took place? You are a defendant in a lawsuit filed in federal court and are alleging to have conspired with attorneys to provide unnecessary medical treatment to workers' compensation patients. Correct? Isn't it correct that the lawsuit alleges that you knowingly profited from alleged medical and diagnostic services rendered as a part of the fraudulent enterprise, including determining the services to be allegedly performed and orchestrating the submission of fraudulent claims from healthcare services? I know this seems crazy, and I know you're going to get a extreme blowback from your adversaries, but just think about it. I chuckle a little bit when I read those words because it's almost crazy that we should second guess asking these questions, right? Because a lot of these cases hinge, whether it be degree of disability, the causal relationship of a new body part, or fraud, on the credibility of the evidence presented. And right from the get-go, not only is the credibility of these doctors in question, but the lawyers that are representing the claimants and the claimants themselves. So this shouldn't seem like a crazy thing to do, right? And just because you get a blowback from these attorneys, many of whom I will remind you are defendants in the same lawsuits, doesn't mean this isn't compelling. And it may not work now, but we are creating a record because this is all going to shake out. And there's clearly a vast conspiracy. And when it does, we have created 1,000 beautiful records for all these cases to be relitigated. So keep the end in sight. Many times the goal in litigating or raising fraud is not a strategic win. We may get a strategic win, but in most cases it's to get a tactical advantage, right? So you want to prepare differently for strategic versus tactical actions. Tactical uses of 114A can result in a compromise or a settlement and the reduction in our client's exposure. Strategic uses of 114A can result in a complete dismissal and a demand for recovery from the employer. Strategic uses serve as a warning to co-employees. A lot of times fraud is raised as a deterrent effect. Our clients love to raise fraud to deter other employees from raising fraud, submitting fraudulent claims, right? Claimant goes out on disability, out 6 months, comes back driving their Escalade. Tell everyone else on the dock, look what I got. I injured my arm last month. I injured my arm 6 months ago. I got 6 months paid vacation, got all my PTO. And look at this Escalade I got at the end of the case. So sometimes raising fraud is to deter other people from committing fraudulent behavior. We can win these cases. Look at our website week after week. Read our newsletter. We can and we do win cases. Our best practice to raise fraud as soon as we have enough evidence to support a proffer. Better to raise an issue and get a tactical momentum than to squander an opportunity. Don't wait for the best situation. Remember what I said about that mundane evidence. You don't need the best evidence. You need evidence that suggests something more than a mere allegation that the claimant has made a false representation in order to maintain an entitlement to benefits, whether that be medical, remember, or indemnity. The advocacy described in this presentation is within each and every one of our control. We are getting conflicting medical opinions. We are offering light duty work. We are investigating and claimant. Get engaged. It's one of the primary ways that we promote one of our core values, which is to aggressively advocate for our clients. So let's start thinking about out-of-the-box ideas to create something better for everyone, right? And that starts with the coordination among the defense bar. It's not enough for us to merely monitor each other's cases and to be up to date on what's happening with these RICO's cases. While these insurers probably cannot coordinate due to their regulated status, defense counsel across firms can come together to share ideas, to spread knowledge, and to discuss techniques, many of the ones we discussed today, to combat fraud. This is why we as a firm publish our wins on our website, to create awareness, to let people know, let the public know fraud is happening. It's something we should be paying attention to. We can do more, like share transcripts and novel techniques. When we invite, here at LOIS, we invite collaboration to do that. Marketing spent by carriers. Think about this. In 2024, major insurance carriers spent $3.6 billion on direct advertising to consumers. Think about that. Imagine if just 10% of that ad money was spent to utilize and to show consumers just how much insurance fraud exists and how much it costs them. More than just taking 10 minutes to save 10%, it could possibly save them millions during the lifetime of a consumer. In other words, While Jake from State Farm or Gecko are great mascots, some of that money could be spent to stigmatize fraud and to save real money. Thank you. Other ways to learn is our very informative newsletter. Of course, everyone here is very familiar with the best podcast in the nation, Christian CSUN's Third Friday podcast. I encourage everyone to listen. Thank you again.